Good morning, everyone, and welcome to this seminar on labor and social standards in the United Kingdom and European Union Trade and Cooperation Agreement. It is with the greatest pleasure that I welcome our colleagues and friends, Giacomo Di Federico, Tamara Harvey, Tonia Novitz, René Repassi. Well, first of all, this seminar will be the occasion to reflect on the importance of agreement in the life of nations and peoples and their relationships, and how agreement can easily and suddenly turn into disagreement. The Brexit effect will not disappear soon in the relationship between the European Union and the United Kingdom, as it shows the paradigmatic clash between France and UK, which occurred in the waters of the English Channel some weeks ago. The battle or fishing of the islands of Jersey is not the first episode of tensions related to the right of fish between the two countries, but is also the result of the tensions generated by Brexit. In fact, Jersey has historically enjoyed a cordial relationship with its Norman and Breton neighbors, and although was never part of the United Kingdom nor the European Union, the island is a crown dependency, as formally agreed to be included in the deal. Nevertheless, the dispute over the interpretation of the agreement has soon become a patriotic dispute, with the English government sending the Royal Navy to monitor the waters around Jersey, and the French government later sending two patrol boats too, and warning to be ready to use retaliatory measures, including cutting off the island's power supply from France. It's not only a matter of political or economic power, though. It comes to mind that Brexit has also been, as Kenneth Armstrong observed, a philosophical challenge for the UK and European Union on how to reconcile their respective demands for regulatory autonomy with a liberal approach to open markets. The TCA reflects this philosophical challenge. The treaty represents a special kind of trade agreements for several reasons. First of all, because for the first time, the European Union signed a trade agreement with the former member states, and differently from other trade agreements, aimed at defining a wide regulatory framework for a variety of issues previously regulated within the European legal order. During the negotiation, while the United Kingdom seemed content to operate according to default international rules, the European Union positions was clear that access to the European market could not undermine its model of a regulated social market economy. And for the European Union, default international agreements and conventions would not be sufficient guarantee of protection against unfair competition. In Kenneth Armstrong's opinions, the result of the compromise eventually reached within the signing of the treaty is a relatively uneven level playing field in legal terms, with variation as to the source of obligations, the agreement itself, international standards incorporated by reference, the domestic provisions of both parties, as well as the applicable enforcement and dispute resolution mechanisms. Today, our meeting will mainly focus on the labor and social standards clauses of the TCA. The issue of non-regression, committing both sides not to reduce levels of protection below current levels, was at the core of negotiations. The UK approach was simply to cut and pass from the trade and labor chapter of the European Trade Agreement with Canada, with both parties committing not to waive or derogate from its labor standard. The European Union wanted something more demanding in its negotiation with the United Kingdom. The treaty recognized the regulatory autonomy of both parties to set their own levels of labor and social protection. However, both the European Union and the United Kingdom have committed not to reduce in a manner affecting trade or investment their levels of protection as they existed at the end of the transition period. The parties are also required to continue to strive to improve levels of protections. This provision is also supported by commitments to have and maintain effective domestic system of enforcement, including access to justice and appropriate and effective remedies. Today's seminar will explore this aspect, suggesting different perspectives of analysis: the UK perspective by Tonia Novitz, the European perspective by Tammy Harvey, the constitutional perspective by Giacomo Di Federico, the international perspective by Rene Repassi. And it's time that I pass the floor to Luca Ratti, who will introduce the discussion. Please be aware that the seminar is going to be recorded and streamed on the YouTube channel of the labor law community. And thank you again on behalf of all the labor law community, to our speakers, and to you all for sharing this reflection. Luca, the floor is to you.
Thanks, Marzia. Thanks indeed for handing kindly over to me. Well, let me briefly set the scene of this seminar and introduce you to the kind of questionnaire that we addressed to our distinguished speakers. The TCA we're looking at was concluded last Christmas Eve and published in the official journal of the European Union the 31st December 2020. And it received the immediate approval from the British Parliament, both the House of Commons and the House of Lords, the same 31st December. But as for the EU side, the much awaited vote by the EU Parliament came much later, only last 28th of April 2021, with an overwhelming majority by 660 votes for, 5 against, and 32 abstentions. And then it was subsequently adopted by a European Council decision. This is a very complex TCA made of more than 1,000 pages, including annexes. And it includes a number of considerations that do not directly impact labor and social standards, but nonetheless that may become of some relevance in the overall appreciation of its main components. But of course, the focus of our seminar will be primarily on those clauses related to fundamental rights, occupational health and safety, and the other important topics listed in Article 6.1, and even beyond, I would say. What is very characteristic of this agreement, as recalled by Marzia, is the European touch on certain provisions and the UK touch on certain other provisions. Can we see that on Article 6.4, where the parties commit themselves to strive to increase and not simply increase their respective labor and social levels of protection? This strive, together with the many places where the parties use the wording encourage or encourages, may have an impact on future commitments of both sides of the channel and on the way such commitments can be enforced. Let's come immediately to the merit of the TCA, on which we see that we divided the analysis into 3 main parts. At first, we focused on the impact of the TCA on the UK legal system, particularly bearing in mind the acquis communautaire, including legislative acts, the case law of the Court of Justice, and legislative decisions, which all remain relevant in the UK as soon as they have been enacted before the same 31st December at 11 p.m. UK time. All that constitutes UK law. But what about any normative act enacted later? How would it match with existing legislation, provided in particular that in the field of social policy, most of existing UK labor law derives directly from EU law? This first set of questions will be addressed by our dear Tonia Novitz, Professor of Law at the University of Bristol and President currently of the LLRN, which will very soon celebrate its 10th anniversary in Poland. The second part is on EU law. This TCA was concluded under Article 207 of the Functioning Treaty on the external action of the EU in the field of commercial policy. What should we expect from the EU law side? How will the particularly the non-regression principle, may be interpreted? Well, since the TCA does never ever mention EU law, nor it implies any role at all for the Court of Justice, what is the real place of EU law in all this? And finally, what is the concrete functioning of the so-called rebalancing procedures provided for in the TCA in case significant divergences emerge? The second part will be analyzed with the help of Professor Giacomo Di Federico, esteemed friend and colleague from my own alma mater, Bologna, and by Professor Tamara Hervey from the City Law School, London. And last but not least, we may wish to look at the two parties involved and see how the respective interests in the field of labor and social standards have been preserved. Here, I think we should bear in mind that this is a purely international law agreement to be interpreted in the light of the Vienna Convention of the Law Treaties, and it has no direct effect at all on individuals, so that citizens and legal persons alike cannot enforce or derive rights or entitlements from its stipulations. Nonetheless, it aims at establishing some sort of level playing field in the areas of environmental and social protection. The TCA does this, referring to international standards, such as those deriving from the core ILO conventions and other international commitments. Whether this is just paper tiger or represent an authentic novelty towards the implementation of the decent work agenda and the ILO Declaration on Social Justice, it remains to be seen. Furthermore, since this is a purely trade agreement, the very concept of trade embedded in the TCA seems particularly underpinned by the reiteration of the impact on trade test. The question here is, how will this work, especially in the light of existing experiences of other trade agreements where such test has been called into question? This third part will be in the hands of Professor René Repasi from the Erasmus University Rotterdam, who extensively studied and assessed the TCA with particular reference to the role of the European Parliament in the implementation of different parts of the TCA. Now, dear colleagues, we are all really looking forward to hearing your views on this TCA. You have been allocated around 15 minutes each in order to then leave some time for Q&A at the end of the seminar. I will be happy to collect questions and coordinate your speeches. So please let me very, very warmly welcome Professor Tonia Novitz. Tonia, the floor is yours.
Thank you. Thank you very much, both for the introduction and for the opportunity to join in these discussions. I've been asked to talk about the EU-UK Trade and Cooperation Agreement, the TCA, from a UK perspective. And I do realize that's going to make me sound rather parochial and obsessed with our UK domestic situation. And now, why would anyone expect that of someone in the UK, especially after Brexit? But in short, my presentation is due to have 4 parts. So the first concerns UK expectations and fears. What happened to the anticipated bonfire of workers' rights? The second part analyzes the shift in focus in the TCA from the EU social acquis to Council of Europe and International Labour Organization, ILO standards. The third considers the importance of enforcement of labour standards to commitments regarding the non-regression on labour laws and what that might mean for the UK. And finally, the fourth part looks at the likelihood of the EU taking action against the UK and the potential changes to UK labour standards that might trigger that response. So on to my first slide here. What did we expect and fear? Well, my colleague Michael Ford QC, in his advice to the Trades Union Congress, our TUC, in 2016, advised that the referendum, if won by vote leave, would mean that all the social rights and employment currently required by EU law would become potentially vulnerable. And working time regulation was certainly at risk, given a private member's bill from a Conservative MP, Christopher Chope, which was presented first in 2015, and that sought reforms which would violate EU law, especially on holiday pay, but a range of other matters. And he's been presenting that bill repeatedly, and it's repeated again in the current session of Parliament, although it's not yet supported by the current government. Michael Ford also flagged the potential for diminishing information and consultation rights, health and safety laws, and even aspects of discrimination law. After the referendum, where 52% of those voting voted in favour of leaving the EU, the European Union Withdrawal Act of 2018 spawned further concerns. Now, on the one hand, as Luke has already said, all EU law would remain in force at the date of British exit of the EU. So the UK has retained, after Brexit, pretty much all the workers' rights placed in our primary and secondary legislation derived from EU law regarding such matters as discrimination, health and safety, information and consultation, and working time. But these entitlements are now subject to repeal or amendment, depending on the current government's political agenda. Further, and this is what many of us found worrying, there is scope for amendment of EU-derived law by subordinate legislation. These so-called Henry VIII ministerial powers can diminish protection for workers' rights by bypassing parliamentary debate and offering potential for autocratic government. Past judgments of the Court of Justice of the EU do remain pertinent after withdrawal under Section 6 of the EU Withdrawal Act, but no future judgment will be, nor will there be scope for references to be made to the court. Moreover, there's now no right of action under domestic law based on the general principles jurisprudence of the court, and the EU Charter of Fundamental Rights, which had set out various workers' rights, is no longer applicable as a point of reference due to Section 5, although of course Council of Europe instruments ratified by the UK remain highly relevant, notably the European Convention on Human Rights, the ECHR, which has domestic legal effect by virtue of the UK Human Rights Act, but also the European Social Charter, and we'll come back to that. Now, Brexit will not have any obvious effect on UK labour laws which were adopted independently of the EU social acquis, such as laws on collective bargaining and industrial action, on the national minimum wage, or as it's now termed erroneously, a living wage, or unfair dismissal, for example, because these are not derived from EU law. They remain as they were previously, vulnerable to amendment and repeal. A bonfire of workers' rights is still seen by some as being threatened, and that was part of a newspaper headline as recently as March 2021. But here we are, a few months after Brexit and the TCA, and we have had no employment legislation since withdrawal. And controversially, there was no employment bill mentioned in the Queen's speech, which announces planned legislation. This is despite promises in the Conservative election manifesto to build on existing employment law with measures that protect those in low-paid work and the gig economy and to improve family-friendly policies. There is just a mention in a Trade Act of 2021 of the need to ensure that if a trade agreement refers to employment and labour, then the provision must be consistent with present UK levels of protection, and that's in section 2. Now, a failure to contemplate an employment bill is concerning since COVID-19 has exposed inequalities and discrimination in the UK labour market, which do need to be addressed, as I suspect they need to be addressed elsewhere. But also, for many of us, the absence of an employment bill is a relief because the systematic repeal of EU-derived employment law is not, as it seems, imminent. And I suppose the question is, why not? Now, this may have something to do with the effect of the TCA, in particular, Part 2, Heading 1, Title 11, especially Chapters 6, 8, and 9, which I'll briefly discuss in this presentation. Despite a right to regulate, which was mentioned earlier in Article 6.2.1, there is a weak non-regression clause in Article 6.2.2, which does not refer directly to the EU social acquis, but rather more generally to labour and social levels of protection and the parties, here the UK's own laws. Of course, due to the EU Withdrawal Act, these include UK labour laws derived from the social acquis, and EU negotiators will have been well aware of that. But in an excellent policy brief for the ETUI, Keith Ewing, Lord John Hendy QC, and Nicola Contouras have made a very pertinent point. While the EU February 2020 negotiating mandate sought to preserve union standards as a reference point, there does seem to be an aversion in the TCA to mention of EU law in relation to labour standards, which comes through even more strongly in Chapter 8. Instead, there's reference to the 2008 Ilo Declaration on Social Justice for Fair Globalization, it's in Article 8.1.1, international recognised core labour standards as defined in the fundamental ILO conventions in Article 8.3.2, and of course implementing all the ILO conventions that the UK and the member states of the Union have respectively ratified, and the different provisions of the European Social Charter that they have accepted. Now, these ILO and European Social Charter standards do not have direct legal effect in the UK in the same way that prior to Brexit, EU law would have done. Michael Ford therefore commented back in 2016 that these would be a poor substitute as a regulatory basis for UK labour law. There have also been claims that the core labour standards and the principles they protect are too nebulous to be of much use. And at the time that the TCA was signed off by Boris Johnson's Conservative administration, the assumption may well have been that these were not legally binding commitments. However, we have seen from the EU Career Expert Panel findings, which were issued later in January 2021, that standards such as principles of freedom of association under the 2008 Declaration, which might not usually give rise to binding commitments under international labour law, may, in the context of specific wording in a trade agreement, have that effect. This shift in focus also coincides with the UK courts referring more to ILO standards. For example, very recently, the ILO recommendation number 198 on the employment relationship was heavily relied upon in our Court of Appeal to give a professional foster carers union the capacity to be registered as an independent trade union. And that was through the medium of reference to that recommendation in a European Court of Human Rights judgment. That's an interesting manifestation of what Virginia Mantuvalu highlighted as a desirable integrated approach, offering new influence perhaps to neglected ILO standards, which may even have a wider impact than EU law did in terms of scope, for example, on collective labour rights. Of course, as Ewing, Hendy and Contreras point out, the UK is actually in long-standing breach of ILO and European Social Charter standards, and the compliance of certain EU member states is probably questionable too. And that raises questions as to how this is going to be played out in practice. On the scope of non-regression commitments, it's been noted in an excellent working paper for the Brexit Institute by Paola Mariani and Giorgio Sacerdoti that Article 6.3 requires, in their words, an effective system of labour inspections in accordance with international commitments relating to working conditions and the protection of workers, effective administration and judicial proceedings. And the provision itself states what is going to be looked for is appropriate and effective remedies, including interim relief, as well as proportionate and dissuasive sanctions. Now, that is precisely what the UK does not have at the moment. There is currently no Director of Labour Market Enforcement in office. The post has been left vacant while it's been advertised for a replacement, even though the most recent temporarily appointed incumbent was willing to stay on until a replacement was found. And this is at a time when exploitation of the most vulnerable workers is occurring in the context of an economic crisis prompted by the coronavirus pandemic and possibly Brexit. As I've said, there is no employment bill, which means that there are no immediate plans for a single enforcement body for workers' rights, which was promised in the 2019 Conservative Party manifesto. The UK's employment tribunal system is overburdened and struggling with almost Dickensian delays, which are more reminiscent of Dickens' novel Bleak House than contemporary expectations of access to justice. So the UK is already in breach here, I think, and many in the UK would be grateful for a prompt from the EU for this Conservative government to get its house in order. Piet Eckert has argued that the EU Future Relationship Act 2020 gives implementation powers to UK courts relating to the TCA. But I am not so sure that despite the Supreme Court's bold intervention on employment tribunal fees, that they can do much more generally about enforcement of workers' rights. That brings me to the scope for retaliatory rebalancing and what might prompt this. Action could be taken against the UK by the EU, potentially through two mechanisms. Under Articles 6.4 and Articles 9.1 and 9.2, resolution of any disagreement in the context of labour and social provisions is not to be determined by the standard arbitration process, but rather through consultations and potentially a panel of experts whose findings would be non-binding. More influential may be the threat of the rebalancing measures that can be taken where there's an alleged breach under Article 9.4 of significant divergence from labour standard commitments, which have a material impact on trade or investment between the parties. And such measures could include tariffs. Bearing in mind only partial EU member state compliance with certain key ILO and EU provisions, there seems unlikely that there will be EU action unless UK deregulatory change is severe or unless there's some other ulterior purpose. Keith Ewing and others have referred to this as a pattern of mutually assured transgression, or at least mutually assured non-compliance. Certainly, I'm not convinced that minor amendments to working time, even those proposed by the MP Christopher Chope, or even discrimination measures are going to trigger EU action. What I think could perhaps do this are the UK government's plans around free ports, which would seem to have both a labour and a trade dimension. Manoj Diasabi and I have written about the government's free port proposals in the context of treatment of immigration and migrant workers. These free ports seem to be export processing zones that the government lauds as new special economic zones. EPZs are now notorious worldwide for their regulatory flexibility relating to labour standards. The government is enthusiastic about creating new jobs through these planned free ports. It's assigned certain cities the rights to create these free ports, but it's silent at the moment on the role that third country service providers and temporary movement of natural persons might play in free ports. It's been said that the national living wage will need to be paid, but otherwise, despite the intervention of the Parliamentary International Trade Commission with a report in April 2021 requesting further information on enforcement of labour standards, very little has been said by this Conservative government. So my recommendation would be to watch that space, the free port space. The TCA may actually act as a deterrent to deterioration of labour standards in free ports, or could prompt EU intervention, perhaps even for other reasons. But I think this is the kind of policy initiative where retaliatory rebalancing might yet arise. And I'm going to pass over to the other speakers for now. I'm very interested in what they have to say. Thank you.
Thank you. Thanks, Tonya. Thanks indeed for clarifying so many points and for giving us this very interesting perspective on free ports, and also for conveying the message that mutual transgression might be the future standard in UK-EU relationships. Now, let me now turn to Giacomo Di Federico and Tamara Hervey. I think Giacomo will speak first, right?
That would be the idea, I believe. I think also that would be better, because what I'm going to do actually is try to draw your attention on the social relevance of free movement of professionals, and in particular healthcare professionals, in light of the pandemic and of course in light of Brexit. So if we agree, so I will be reviewing the current legal framework at the EU level and see how it has worked, and try to verify how in the future there could be free movement of healthcare professionals between the EU and the UK, and what room, let's say, the trade deal leaves in this regard for action. So if we agree that access to healthcare is part of the basic fundamental rights of every individual, and that universality is a specific manifestation of the social dimension of healthcare services, as construed, of course, in international and EU law, I thought it might be interesting, especially in light of the propaganda which accompanied the referendum campaign, to consider the impact of the EU-UK trade and cooperation deal on free movement of health professionals. And this I will try, as I mentioned, to do in light of pre-Brexit mobility trends, which I think are interesting to consider. And most notably, I will focus on the, of course, the very specific system of recognition, which is automatic mutual recognition. Now, under the withdrawal agreement, just let me restate what is pretty well known. All EU-EEA workers already resident in the UK will have to apply for an EU settlement scheme before the 1st of July 2021. Now, those who intend to travel to the UK to work in the healthcare sector after the 1st of January 2021 instead will have to comply with domestic immigration rules. Now, in truth, it appears that these categories of workers, especially essential during the pandemic, of course, will have preferential access in the points-based system. Now, this means, amongst other things, being exempted from the Immigration Health Surcharge pursuant to the Immigration and Social Security Coordination Act of 2020. And however, notwithstanding these adjustments, it is clear also to the UK government that international recruitment is and will be paramount for the functioning of the NHS, which appears to be a factor of identity for UK citizens. Now, in this regard, suffice it to recall, there's a lot of data on the subject, but to recall that approximately 15% of those employed by the NHS are not British nationals, with around 5% coming from EEA countries. And also, I would like to remind you that according to the UK government, it will be necessary to recruit from abroad an additional more or less 12,000 nurses by 2024, 2025. So this would appear to be a pretty critical situation. Now, as will be seen shortly hereafter, and I really hope it will be shortly hereafter, there are additional measures aimed at favoring free movement of health professionals. But let me be clear, the impact of Brexit on the health workforce of the NHS falls, of course, beyond the remit of my intervention today. As an EU lawyer, I shall confine my thoughts in accordance with the role which the organizers have assigned to me, the EU perspective. Okay, now that being made clear, I would like firstly to rapidly resume the legal framework as I anticipated. Secondly, to consider the reasons and magnitude of the phenomenon which was abruptly interrupted with the June 2016 referendum. And finally, look at how the Commission has used this legal framework in a very flexible way during the pandemic. And this should give us an idea of the added value of the regulatory framework within the Union. And I think that is something that the UK will in any case have to look at for future in terms of minimum coordination for the future. Okay, so very rapidly, strategic workers in the fight against COVID-19, such as doctors and nurses, I will be mostly focusing my attention, making reference to these two categories. Well, these, as I mentioned, and as you might know, are subject to automatic recognition pursuant to Directive 2005/36. The latter, as you might know, sets minimum requirements for training, hours, competences, skills with reference to very specific doctors and nurses in this regard. Let me remind you that Annex 5 of the directive lists other professions such as midwives, pharmacists, dentists, and also let me remind you that following the introduction of the European Professional Card in 2016, also physiotherapists are included in the system of recognition. Now, to promote free movement, let me stress this. Member states are required and, let me add, encouraged regularly by the Commission to update, to map, and review the list of regulated professions. And let me insist on this point because it has emerged during the pandemic, specializations. This is one of the limits of the system, I would say. If we look at the EU level, we will see that Annex 5 has been adjourned, updated regularly since 2016, 17, 18, 19, and at the best of my knowledge, the last update is of 23rd of January 2020 with delegated decision number 548/2020. Okay, so obviously, the possession of the diplomas and relevant certificates, which we find listed for transparency and legal certainty in the annex, should be enough in principle to have access to the labor market of any other member state. And however, however, I have to remind you that there are administrative procedures in place, and you have to comply with those procedures. Those procedures, of course, are set at the national level, which means that member states can require documents. This is especially the case for health professionals because it is a matter of guaranteeing safety, of course. Now, so what this means, it means that you can find burdensome administrative procedures, and they're certainly not cost-free. This appears to be one of the main limits. If you take the system of automatic recognition, let me just give you an idea of the success rate for nurses when they apply is above 80%. So as a nurse, when you apply automatic, and the directive also gives us an idea of the timing. So within 1 month, you have to react as a national authority to the application. And within 3 months, you need to, as an individual, get a reply. Can you hear me?
Yes, we can, Giacomo.
Okay, we'll proceed. And within 3 months, you need to have received a decision, and that decision can be taken to court. So this is, again, a very important thing to underline. Let me also remind you that problems concerning compliance with the requirements of the directive will be handled within the internal market information system, which allows competent authorities to communicate through a dedicated platform and prevent abuses. This is very important for safety and health reasons, of course. Let me also remind you that incompatible domestic measures can be contested via the preliminary ruling procedure or the infringement action, or more rapidly, let's say, through the Solvit system, which is a network of national contact points charged with the task precisely of clarifying the applicable legal framework and removing undue restrictions. Now, let me also remind you, let me come back to the specialization problem I was mentioning before. When you have specializations which are not harmonized, what might happen is you have certain qualifications and skills do not necessarily are not the same in the other member state. And so the idea is that in some cases where these competences are significantly different, the member state, let's say the host member state, can impose an aptitude test or an adaptation period, again, to guarantee for safety and health reasons. Now, as you might know, in 2013, this legal framework has been enhanced. Directive 55 of 2013 was adopted and introduced a number of modifications that is worth mentioning because, in particular, above and beyond the European professional card I have already mentioned, we're looking at mandatory use of the internal market information system, which enhances legal certainty and safety, of course, and also, here I get back again to the specialization problem, partial access. According to the directive, member states should facilitate partial access to the profession. So instead of systematically asking for aptitude tests or training periods, what they should do is facilitate free movement of workers and therefore grant partial access to a profession, to certain activities of a given profession, just to be clear. And of course, new simplified rules on language. Okay, language is one of the elements that you can require as a member state for a health professional. Of course, if you're a nurse, you have to understand, and doctor, you have to understand what the feeling, the state of the patient, and therefore you need to speak to the patient and understand. This is very, very, very important. of course, in terms again of health and safety. So it is, according to the latest indications, what the member states should do is A, verify the formal qualification, B, verify the language, and not carry out the same operation at the same time. Now, in this regard, I think it is clear with these only brief considerations that the directive has an undeniable added value. And I think the UK government understood this when it decided to apply unilaterally the system for an additional period of 2 years. So there is no reciprocity. The choice as to whether to recognize UK professionals in the EU will depend on the member states. I may be able to resume this argument at the end of my intervention. Let me, though, because I think this is the central part that I wanted to bring to your attention, let me focus on the reasons and magnitude of the phenomenon. Why is this technical legal framework I've tried rapidly to resume, why is it relevant in social terms? Because if we look at the pre-Brexit mobility trends, we find out that in 2017, there were 9.5 million active movers in the EU. That was the 28 EU, including, of course, employed and job seekers. The main countries of destination, you might know, were Germany and the UK, followed by Spain, Italy, and France. And the principal countries of origin were Romania, Poland, Italy, Portugal, and Bulgaria. Now, if we look at, this is in general terms, okay? If we look at the health professionals, health associate professionals, and personal care workers in the health care sector represented 7% of all employed EU 28 movers. Again, the main countries of destination were Germany and the UK for health professionals, and Italy for personal care workers. And the main countries of origin in total numbers, then there are specificities, of course, were Romania, Poland, and Italy. So you see, Italy, you can find the same country as country of origin and destination according to the specific healthcare profession. European citizens tend to move, according to surveys I've had a chance to study, either for family reasons, so to join a family member or relatives, here I get closer to the social argument I want to put forward, or in search of better career opportunities, to find a job, or a better job, or a better paid job. The decision to move, of course, depends on many factors. They are personal, but at the end of the day, there are also macroeconomical and political. And this, of course, I can't touch upon the issue of rule of law within the union, but of course, it is there. The existence in particular today of notable, extremely notable differences in salary between EU member states plays an important role, very important role. And nurses from Bulgaria, for instance, have declared they're willing to accept a job below their skill level in Sweden, because in any case, it is paid up to 5 times more. Okay, so, and also shortages, and here I come to the UK. Shortages of specific professional figures can also play an incentive, can also be an incentive to try to attract workforce from abroad. In Germany, for instance, they had a problem with people caring for the elderly, and they implemented a program, specific program for training nurses. In Italy, where they noticed a drop in people studying to be a nurse, they changed the program for multi-skill training, trying to make this more attractive. Okay, let me also, of course, geographic proximity and language play a crucial role. Okay, I will follow that indication. Third part. So let's see how the legal framework has been managed during the crisis, during the sanitary crisis. Of course, swift recognition of health professionals is paramount, it's pivotal. And in this respect, on the 6th of April, the Commission adopted guidelines on EU emergency assistance in cross-border cooperation in healthcare, reminding the member states that the directive 2005/36, as amended in 2013, does not prevent them from being more flexible when it comes to accepting incoming health professionals. In particular, administrative formalities can be removed and application procedures can be accelerated. Think of shorter deadlines, fewer supporting documents, more relaxed stance towards compensation measures. These are all suggestions put forward. Now, there are many, of course, other suggestions in the communication and guidelines that the Commission has adopted starting from March 2020. But my time is up, of course. However, I want to insist on one aspect, and I do this in this context, because I think that against all accusations of immobilism, absence of strategy, compliance-driven approach, and so on, the Commission, but not only the Commission, of course, there are a number of agencies which have contributed to the success, has proven capable of taking the much celebrated all-it-takes approach, doing everything it was allowed to do under the treaties, and as recognized by Ursula von der Leyen, even more, in the attempt, of course, to ensure healthcare services during the sanitary crisis. So let me just, couple of final remarks. It remains to be seen, I think, to what extent the social care sector will be affected by Brexit now that the trade agreement is in force. But I do believe that at least in relation to doctors and nurses, and in the post-pandemic scenario, international recruitment will still be possible so that the proper functioning of the NHS will not be endangered. In addition, and perhaps more importantly, there seems to be room for further cooperation in the future because independently of any voluntary legislative convergence, the TCA does contemplate the possibility of developing new mechanisms for mutual recognition of professional qualification. And if normative alignment is made dependent on a positive economic value of mutual recognition, I think it follows from the above, from what I have said up to now, that the link should not be too hard to establish. I think that's per se, there's an economic value there. And indeed, it appears that professional regulatory bodies are currently working with the UK government on registration requirements after January, after that 2-year period I was recalling at the beginning. So after January 2023, for those who have obtained, of course, qualifications in the EU or EEA state. So let me conclude. This is not a matter only of economic relevance. In social terms, the loss of free movement for professionals, I think, has a significant, let us not forget this, negative effect on family members, regardless of whether they are seeking employment or not. And this is what the data tells us, how we are looking at workers, but we also have to think of the workers with their families and minors. Thank you very much for your attention.
Thanks, Giacomo. Thanks indeed. You conveyed very clear messages, very much in line with what the representatives of the European Parliament did at the end of the voting period, when they said that this is the best agreement that could be agreed given the current conditions, and this is a living agreement, so needs still to be adapted, particularly in the field of healthcare. I'd like to turn now to Tamara Hervey, who will in particular focus on no regression provisions. So Tamara. The floor is yours.
Thank you so much. I am absolutely delighted to be here virtually with you all, my friends and colleagues, and to be part of this extremely interesting discussion. I'm learning a lot, and I'm very much looking forward to the conversation after the presentations. So let me tell you a little bit about my focus and what I aim to cover in these next few minutes. So I've been asked to focus on the non-regression provisions, so we'll kind of refer back to some things that Tonya has already covered from the UK perspective, but my perspective is more from the point of view of the European Union. I want to focus on these provisions that are found in Title 11 of the Trade and Cooperation Agreement, and I want to do that in the context of the EU-UK Trade and Cooperation Agreement as a whole. I want to stress what these provisions are not, if you like, and you know, in particular that they are not European Union law. Then I'll spend a little bit of time just talking us through the content of the provisions, and then finally I'll come to some introductory remarks about enforcement, but I'm sure we're going to talk more about that in the conversation that follows, because I know that Tonya and others present will have other things to say and to add to what I have to say about enforcement. So let's just start by talking a little bit about the context of the agreement as a whole. This is the moment where the agreement was reached, a huge amount of relief for many people, especially in the UK, that there is an agreement and we don't have a no-deal relationship. So this is an international trade agreement, and it's extremely important to remember that that's what it is from the point of view of the EU and from the point of view of the UK. It entered into force, as we've heard already, provisionally at the beginning of this year, and formally just this month. Its aims are, unlike the European Union's usual trade agreements, this trade agreement aims to have less integrated trade relations between the two parties than was the case before. So it's different from the European Union's normal trade agreements, where the European Union is trying to have more integrated trade agreements than before. It gives the EU and the United Kingdom more regulatory autonomy from each other than before. So unlike EU membership, this is more like the European Union's standard approach to international agreements. It involves access to each other's markets for goods. It involves some limited access for services. But there are some elements of the Trade and Cooperation Agreement that go further than these trade aims. One really important chapter is the chapter on coordination of social security provisions, which could be the subject of a webinar all by itself. There's a huge amount of legal technicality there that we're only just beginning to think about, and it will be very important. It will be important also in the context that our colleague Giacomo was just talking about. What happens when a health professional moves from the UK into the EU? Will she be able to bring her pension with her? Will she be able to bring access to other social security provisions? Those things are covered in the Trade and Cooperation Agreement. But that's not my focus today. My focus today is on these labour and social standards provisions. These are among the elements that go a bit further than the trade, the strictly trade parts, or the access to market parts, better said, of this agreement. And we see this in the preamble, which refers to the economic partnership between the European Union and the UK being underpinned by a level playing field, including a commitment to uphold high levels of protection in areas that include labour and social standards. And we also see this in Article 1, which refers to autonomy and sovereignty of the parties. Now, it's quite interesting to think about the European Union having sovereignty, but again, that could be the subject of another whole webinar, so I won't detain us on that any further. Now, what this isn't, at the risk of stating the obvious, it is not European Union law, although it is European Union external relations law, and so it will be subject to the acquis communautaire on external relations. It is not harmonisation of standards. It is not mutual recognition. There are some common institutions like the Partnership Council and the Trade Specialised Committee on the Level Playing Field, but these are not the European Union's institutions. There is no common approach to interpretation of the Trade and Cooperation Agreement's provisions. There is nothing like the preliminary reference procedure. And there is nothing like direct effect. The Trade and Cooperation Agreement does not give rights to or impose obligations on private individuals. And this is not a human rights instrument. Again, unlike in European Union law, labour and social rights are not seen as human rights within this instrument. And again, Tonya has touched on this point already, and we may well pick it up further in the conversation. So this is Title 11 on the level playing field, and it begins with this very general provision. And these acknowledge that the trade relation between the European Union and the United Kingdom, because the United Kingdom has been a member of the European Union, is such that it is necessary to prevent either party from distorting trade by changing national requirements or measures in a range of areas that include labour and social standards. So it's the previous integration that forms the rationale for the level playing field provisions. Now, we might be a little bit skeptical about this in the sense that it's not so much the previous integration that's the reason, it is the size of the UK market and its geographical proximity to the European Union that really prompts the necessity from the European Union's point of view for these provisions. But this is not harmonisation, and this is stressed in these general provisions. The point of the agreement is not to harmonise standards. So here is the content, or the beginning of the content, of the Labour and Social Standards of Protection Clause. This will be familiar to many in the audience, but I think it's worth reminding ourselves just of what is here. So it covers all the key areas of the acquis on labour law: fundamental rights at work, which presumably includes equality rights, such as equal pay for men and women, non-discrimination on grounds of race and disability, and labour rights found in fundamental rights instruments such as the European Social Charter, health and safety at work, fair working conditions, which between them all obviously presumably include working time, holiday pay, and so on. The provisions on information and consultation on restructuring and transfer of undertakings. These provisions do not cover related social rights like social security entitlements or pension provisions. So this is the substantive content, and here is the obligation. So in Article 387, subparagraph 2, the obligation is that neither the UK nor the EU shall weaken or reduce, including by failing to enforce, labour and social levels of protection below the levels in place at the end of the transition period. And this is the crucial bit: to the extent that this takes place in a manner affecting trade or investment between the EU and the UK. So the transition period ended on 31st of December 2020, so that is the baseline or benchmark. Some questions come to mind. What if the UK's approach to implementing EU standards was not compliant with EU law at 31st of December 2020? What standard applies then? What if this had not been determined explicitly by the Court of Justice of the European Union under its jurisdiction in Article 258 of the Treaty on the Function of the European Union? I can think of one example where this might be the case. The UK does not recognise the definition of disability discrimination in the UN CRPD, which is based on a social model, whereas the European Union has signed the UN CRPD and the ECJ's case law recognises the social model. I'm sure others here will be able to think of more possible examples. Another question that springs to mind. What if a provision of European Union law, let's say a health and safety at work directive or an equality directive, in place before the end of 2020, is subsequently interpreted by the Court of Justice of the European Union to show that the UK has actually departed from the standard that was in place at the moment of the 31st of December 2020. When the Court of Justice of European Union interprets European Union law, in principle, it is not making new law, it is stating what European Union law has always meant. Further questions come to mind. What is the threshold for an effect on trade or investment? Is there a de minimis rule that applies? Or is it more like the approach found in the Court of Justice's reasoning in the Dassonville case? Any effect, direct or indirect, actual or potential? So you can see that there's plenty of scope for disagreement about what the terms of the Trade and Cooperation Agreement might mean. Now some words about enforcement. In principle, enforcement of the relevant labour and social standards is to be domestic enforcement. Remedies have to be appropriate and effective. There is a reference to international standards, international commitments. Again, there are many possibilities for differing interpretations between the parties. Turning now to dispute resolution. So in general, dispute resolution is governed exclusively by Articles 408, 409 and 410 of the Trade and Cooperation Agreement. But there are some links to the Trade and Cooperation's general horizontal dispute settlement arrangements. The first port of call, should a dispute arise, is the consultation phase. Consultation is supposed to reach a mutually satisfactory solution. And resolutions reached under this consultation procedure must be made public. There are important transparency elements to the dispute settlement arrangements in the Trade and Cooperation Agreement. Parties have to spend a minimum of 90 days attempting to consult. If that fails, the next phase involves a panel of 3 experts. A cadre of 15 panellists established by the Trade Specialised Committee on the Level Playing Field for Open and Fair Competition and Sustainable Development must be established. Panellists have to be independent from the European Union and UK, but they have to have specialised knowledge or expertise in labour law. Time limits apply to the work of the panel. The panel has to produce an interim report, which is reviewable at the request of either of the parties, and then a final report. The panel report has to be made publicly available, it has to be reasoned, and it has to have a finding of fact and a determination of the matter at issue. Implicitly, the panel may make recommendations. The panel's report is determinative of whether there has been compliance or breach, but there is no legal consequence of any recommendations that the panel might make. As I mentioned, implicitly, the panel may make recommendations. That's implied in the text of Article 409, subparagraph 9 of the Trade and Cooperation Agreement. But there's no legal obligation on either party to follow any recommendations that the panel might make. And failure to do so is not necessarily a breach of the Trade and Cooperation Agreement. In other words, there could be another way for the parties to comply with the Trade and Cooperation Agreement, different from the recommendations that the panel might make. So this is very, very far from what happens in European Union law, where the Court of Justice of the European Union's decision is dispositive, is binding on the parties, and is determinative of the acts that need to be taken in order to be compliant with European Union law. A couple of words about the rebalancing phase. So this is a novel mechanism specifically for this aspect of the Trade and Cooperation Agreement. It applies where there is a significant divergence. Again, questions of interpretation will arise here, and Tonya has already touched on what might be a significant divergence. An adjustment to the working time rules might not be significant. Creating free ports that basically don't comply with the labour rules as set out in the benchmark in the TCA might well be a significant divergence. So this novel mechanism applies where significant divergence in labour and social protection standards arise, which results in material impacts on trade and investment. In that case, either party may adopt necessary and proportionate rebalancing measures based on reliable evidence, not on mere conjecture or remote possibility. The relevant procedure has a notification obligation, a 14-day consultation phase, and a possible arbitration phase of 30 days before rebalancing measures can be introduced. The arbitration determines whether rebalancing measures are indeed proportionate. There is a possibility for countermeasures if the arbitration is not carried out in time. Now, most commentators who I've been able to read in the short time available to prepare for this presentation, most commentators agree that these provisions are more robust than in an average European Union trade agreement. Some people have suggested that the combination of these rules and the horizontal dispute settlement mechanisms in the Trade and Cooperation Agreement mean the possibility for cross-sectoral retaliation, suspension of parts of the Trade and Cooperation Agreement, including reintroduction of tariffs. The question of how to meet the requirement that divergence in labour or social protection standards has a material effect on trade or investment might mean that this is in fact a remote possibility. Showing that a change in UK standards has such a material impact might become an impossible barrier for the European Union to meet. Apparently, according to the trade expert Holger Hestemeyer, the only known decision on the impact of labour-related actions on trade is a case brought by the US, where the arbitral panel concluded that although the Guatemalan government had failed to enforce its own labour laws, the effect on trade was not proven. The authors of this report, on my slide on the Guatemala case, point out that the best way to solve this weakness in the relevant free trade agreement would be to remove the clause in the manner affecting trade and to interpret labour law rights chapters of free trade agreements as human rights provisions, as basic rights of workers, in a similar way to the way that intellectual property rights are often treated in free trade agreements. But as we have seen, the UK-EU Trade and Cooperation Agreement is far from treating labour and social rights as freestanding human rights, inherent in all workers in the UK and the EU. The rebalancing provisions are a way of recognising the special circumstances of the EU-UK Trade and Cooperation Agreement, and especially the fact that the UK and the EU are still deeply economically intertwined, that the UK is a large proximate market to the European Union's, and that the UK begins aligned with the EU in regulatory standards, including labour and social standards, on the 1st of January 2021, but that the two parties could diverge in the future. But ultimately, these rebalancing provisions are provisions of a free trade agreement, and that will set the stage for the way that these provisions are interpreted and applied going forward. This is just acknowledging the various funding sources that have gone into this research, and thank you very much.
Thanks, Tamara. Thanks indeed. Through the door of non-regression, you took us through a very rich set of provisions, both substantive and procedural, that I suspect will be at the core of our debate during the Q&A moment. So, and thanks very much for that. Let me now turn to our last intervention for today, Professor René Repasi on the international law side of the TCA. René, the floor is yours.
Okay, thanks a lot. Thanks a lot for having invited me to this workshop. As a pure international European Union lawyer, I am always delighted if specialized law fields are actually inviting us generalists to talk to. So from my own origin, I'm of German origin and I studied law at the University of Heidelberg, and labor lawyers there until today don't recognize that something like EU law exists and that it has implications for labor law. And that was somewhat my prejudice that I had towards labor lawyers until I came across this community that recognizes this effect and actually wants to know more about it and work on it. So I'm very delighted to be here and give you some thoughts on the matter. And as it came already across in the previous statements, labor and social standards in the TCA, this is one of the core discussions that we're going to have in what is going to come. In the details, we have seen where a lot of, how should I put it, elements of discussion there are, disputes there are, that will keep us lawyers busy for years. And in order to multitude the complexity to it, the international perspective will come into play. Because as Luca rightly pointed out in the very beginning, this agreement is, although it has a lot of notions and references to what we might know from EU law without being explicit, although it is an international law instrument. And the parties explicitly mentioned in the general parts of the agreement, this is international law, and the rules on interpretation of the Vienna Convention on the Law and Treaties shall be applied to it. So in that sense, international law might give some guidance as to where we are going to. But how is it, as a more general terms, how is the situation of labor and social standards in international law now? That might be a couple of things that are known to you. Therefore, I'm going to be rather quick on that part and be a bit slower on the part when I'm zooming into the detail. Now, the issue of labor standards in international law, it is well known. We do have factually already a disbalance between elements of market transactions, capital goods, services as compared to labor. In a sense that the former, so capital goods and services, are highly mobile. They can highly cross borders without much problems. And that is different to people. So labor is rather immobile de facto. And that has as a consequence also that the legal protection that workers have in our globalized community are, as it stands currently, exclusively to be sought in front of domestic courts and then in accordance with domestic law and procedures. So in contrast to investors, there are no international tribunals or arbitration panels open to them. There's one exception, one very notable exception, even being classified as international law, and that is, of course, as mentioned at many moments already today, that is EU law. Don't forget, the EU treaties are also an international treaty. And the strength of the legal protection for workers' rights under EU law are the two old principles of direct effect and primacy that make it that when workers' rights are to be sought in front of domestic courts and in accordance with domestic law, that they can rely on EU law and that they are part of domestic law. Now, when we are looking at what are common labor and social standards, you all know there are the Ilo Labor Standards. They are meant to harmonize workers' rights globally, and to the extent that they are then respected by parties, they form some kind of acquis mondial. The ILO labor standards are well known and they have a high amount of ratifications, but as it's also well known, a low compliance rate. especially being that far that non-compliance with any ILO labor standards does not lead to any kind of sanctions, which basically leads some authors to the statement that the ratification of core ILO conventions is negatively associated even with workers' rights, because having them means not respecting them. And everybody, any state that is ratifying those ILO conventions can say, look, we are compliant, we have those conventions ratified, but non-compliance doesn't really matter. And that makes it that the multilateral approach to protecting labor and social standards in international law must be considered at the moment of time, at this moment of time, as failed. And that brings our attention to labor and social standards in trade agreements as the TCA. Now, what we see in trade agreements, be they bilateral, be they multilateral, are two kinds of requirements. The first requirement is the requirement to implement minimum labor standards. So in that sense, trade agreements want to remedy the lack of compliance under ILO law by putting compliance as a part into their trade agreements. They are framed in two ways. And here we are already zooming a little bit more into detail because that might become most interesting for the EU-UK trade agreement. So they are framed as commitments to respecting, promoting, and realizing ILO principles. That's typical international law language. It seems at first sight, like, what does it mean? The interesting thing is now, if we zoom into a very recent example that we find in EU trade agreements, so in the EU-Korea Free Trade Agreement, this is the language of Article 13.4, paragraph 3, subparagraph 1. The wording is comparable and in times even similar to the one that we find in Article 399, paragraph 2 of the TCA. I'm using here the most recent numbering as of 30 April. There's some confusion, but I adjusted it to the very recent one, just as Tamara did. And here we have this interesting panel of expert report of 20 January 2021, which was already mentioned. And here the panel decided that this commitment, although it was in the trade sustainability chapter, is to be considered a hard and binding obligation. So it is not only a programmatic kind of source of inspiration for policymaking. No, the panel went further and said this commitment is to be understood as a hard and binding obligation. So violations of ILO conventions and declarations are considered violations of such commitment. That is the substantive part. What follows from this is a question that is to be separated from this. But here we have already, at least for the EU, a step further in this panel that such commitments are to be considered hard law. The other way of how it is framed, and here we come to the consequences side, that they are framed as best effort obligations to ratify ILO conventions. I mean, we know that even the so-called Western countries have not all ratified the ILO core conventions. And an example for such a rule is also to be found in the same agreement with Korea. The parties will make continued and sustained efforts towards ratifying fundamental ILO conventions. So the first one refers to there are principles that you are adhering to. The second one is referring to conventions that still must be ratified. And here, the same panel of experts report said the very fact that Korea until now has not yet ratified certain ILO core conventions does not mean a violation of this best effort obligation, because the trade agreement did not specify a specific time frame within which the ratification has to take place. So since we have also a comparable formulation like that in Article 399 of the TCA when it comes to ILO conventions. So here we see if there is ILO law that is considered to be binding either because it's customary international law or there's ratification, then we have the commitment one that is supported, that is understood as hard law, and if there is not yet any such binding force, then the best efforts obligations doesn't bring us much further. Now, this is the one category of provisions we find under international law. So requirement to implement minimum labor standards that are defined at global level. The other one are the ones that were discussing recently in more detail. So non-regression clauses and non-enforcement clauses that look at not lowering existing levels of protection of labor at the time of the entry into force of the trade agreement, with all the issues in detail that Tamara was referring to. And the other one is, of course, looking at the enforcement. But there's also a third category, but this category cannot be really filled up because there's not much to say. It is about clauses regarding future divergences. Because what non-regression does, it's freezing in a certain standard at a certain moment of time, but what is happening thereafter? If, for example, now the European Union is increasing its own standards, what is the consequence of this if that leads then to divergences because the UK is not following? Remember, this was one of the big points in one of the big negotiation goals that the European Union had with regard to the future trade agreement, that there's going some sort of regulatory alignment so that the UK and the EU are continuing to increase their standards, something that is not found back in the TCA itself, but where there's some sort of compromise between the UK not wanting to have anything like this and the EU wanting to have regulatory alignment. That is the rebalancing provision. And I believe in this light, the rebalancing provision has also to be interpreted given the history of the coming into existence of this rebalancing provision. And that brings us, of course, to the issue of the trade relevance. Tamara mentioned it. Any lowering of labor and social standards must affect trade between member states or promote foreign investment. That is the standard kind of drafting that you see in trade agreements, not only the EU, but also from the United States. So what does affecting trade or investment between parties mean? Now, Tamara already mentioned the one famous case of the United States versus Guatemala, in which the issue at stake was the non-compliance of Guatemala with labor law and labor rights. And we are not talking about details like working time. We are talking about fundamental things like the failure to protect trade union leaders and members against violence. So this is core ILO issues, and that it happened very easy to prove. And if you look at the provision that was under review in these procedures, this Article 16.2, paragraph 1, letter A of the Central American Free Trade Agreement, then you see precisely the same wording, in a manner affecting trade between the parties. And the arbitral panel said the following: the United States failed to prove that there were cost savings from specific labor rights violations, and that these savings were of sufficient scale to confer a material competitive advantage in trade between the parties. Now, this is a very high standard of proof. Now, world trade lawyers were, from their perspective, interestingly, applauding these judgments, whilst EU lawyers find it rather weird. And here you see the different kind of perspectives that there are, because the only thing of trade remedies that WTO and trade lawyers knew about was WTO safeguards. And if you take WTO safeguards, then the standard of proof is even higher, because you have to prove that there was an injury of substantial industry-wide repercussions. So from the perspective of WTO law, the Guatemala case was lowering the standard of proof. From the perspective of EU law, and Tamara was mentioning it, we know the does and will formula, which is actually rather opening the scope of EU law than limiting it. This is a high standard of proof. And honestly, in reality, it is a high standard of proof. Because if we look at working time, for example, etc., how can we come up with cost savings that are of such sufficient scale that it confers a material competitive advantage in trade between the parties? Very difficult. One remark at this point, because look at the language. This decision was known when the negotiators of the EU and the UK were negotiating their agreement. And look at the difference of languages between the non-regression clause that was asking for in a manner affecting trade between the parties, and the rebalancing one that was speaking of a material impact. Look at the definition given by the arbitral panel. So the arbitral panel was actually defining in a manner affecting as referring to a material competitive advantage. It brings me honestly to the conclusion that the difference is none between rebalancing and non-regression. So a manner affecting trade between the parties is in both provisions to interpret it in the same manner. Yet we speak of a material and competitive advantage if we want to follow this arbitration case. And here we come, there is no such thing as stare decisis in international trade arbitration. And look what we have from, oh, here the date is not right, it's 20 January, not 25th, in again, the Korea Panel of Experts report. Here we had an issue that was not related to non-regression, because here we were talking about non-implementation of labor standards as part of the trade and sustainable development chapter. But the Korea agreement also has a non-regression clause that is precisely drafted in the same way as the Brexit one. And South Korea argued in the case that the trade relevance criterion from the non-regression clause has also to be applied in the same way to the TSDD chapter. And therefore, the panel discussed what is meant with the DR-CAFTA arbitral panel final report that I was just mentioning. And the Korea panel decided we see this differently. And the Korea panel, in my eyes, correctly said, guys, we are here having a different contextual setting. So the relationship, the trade relationship, and the entire agreement understanding between the United States and Guatemala is a different story than between the EU and South Korea. If you also look at the trade relations, if you look at the trade streams, if you look at all these kind of things. And that makes it, we have to qualify the manner of affecting the trade between those partners differently, looking at the specific circumstances of the trade relationship. And they concluded then that national measures implementing fundamental labor principles and rights are inherently related to trade. And that is opening the door for an interesting interpretation, because it basically says if labor and trade are inherently related to each other, then any kind of lowering of labor standards is affecting the trade between the parties, because labor is inherent to trade. I am frank on this. I also have to make my own convictions transparent in this kind of meetings. I am a social democrat, and on the basis of these convictions, I believe this is totally right. Yet I believe that liberal trade lawyers might have a different view on this. Yet the arguments I find rather compelling. There's also another development in this. The United States had ratified a follow-up on the NAFTA agreement, the USMCA, in which they also addressed this issue. And the United States learned of the fact that they lost a clear-cut case in the Guatemala one, and they put in this agreement a change of the burden of proof. In Article 23.4 of the USMCA, it is said in a footnote, for purposes of dispute settlement, a panel shall presume that a failure is in a manner affecting trade or investment between the parties, unless the responding party demonstrates otherwise. So also here, the development is that any lowering of labor standards is actually presumed to affect the trade between the parties. But now Guatemala or whoever else is coming there must say that this is actually not the case. And given the complexity of the standard of proof that the arbitral panel in the Guatemala case was setting, we are going to have quite often non-liquid situations in which then such burden of proof rule might be important. It was also back then, therefore, my recommendation to the European Parliament to precisely adopt such understanding of the non-regression and rebalancing clauses to say, for the purpose of dispute settlement, any weakening of labor standards shall be presumed. I personally also believe that this makes sense. I will mention it later in the preliminary conclusions again. The relationship between the UK and the EU was determined for 4 decades by harmonized labor law. So we have here 2 legal regimes that are actually the same, and they are now separated. A total different story than the legal regimes between the US and Guatemala, and even different than the EU and South Korea. And that makes it that the intrinsic trade relations, the very deep trade relations, the trade exchanges and the amount we are talking about, combined with the legal regimes that are actually the same, that here any weakening of labor standards must be considered as a manner affecting the trade between the parties, because it's a different story when states are that different from each other, and then there's another lowering of labor standards as compared to states that are like this, and then there's a lowering. In relative terms, this is way more significant than when you are in such a situation. The core question remains how to enforce compliance with these. And here we have a US approach. Until now, upholding labor standards is subject to an interstate dispute settlement mechanism that has as a consequence the suspension of benefits, something that we have not seen back in EU trade agreements. Their approach was dialogue one with a panel that can issue non-binding recommendations. Tamara was mentioning it. And that changed now with the EU-UK agreement. Now, let me run here quickly through it, but that is only a reminder because many of the other speakers have already mentioned it. The biggest shortcoming of it is that it has no direct effect. This is the power tool of EU law, and this power tool is not in TCA. So it clearly says there is no direct effect. And that is basically weakening the enforcement of workers' rights significantly, irrespective of whatever comes thereafter. Now, if we go to the level playing field, let's have a short look. I'm just repeating what the other speaker said, but I have put it in a nice graph. So if you go into the level playing field rules, we have defined 6 areas of level playing field and 4 elements that are necessary to look at. The first one, how is it enforced? Is there a locking in of existing standards? If there is a lowering of any of those locked in standards, is there a possibility to remedy it? And how do we deal with divergences? Now, what interests us is labor and social standards. And here we see that TCA is giving an answer to all of them. For enforcement, they establish an obligation to have effective domestic enforcement. In detail, is this sufficient? Different question, but they establish it. They establish a non-regression clause, and they allow for temporary remedies if the non-regression clause is violated. On the top of it, and that is the innovation part, is they even protect against future divergences, which might be triggered by the EU increasing their own labor and social standards. And that's the picture if you look at the other elements of it, which already shows only environment and climate are as strong in their protection as labor and social standards, and all the other fields, they lack some other elements to be considered fully fledged level playing field protection. If we look at the sanctioning system, then what is allowed also under this agreement is, of course, the reference to WTO trade remedies. Here, I mentioned it, safeguards are the only ones that might matter under labor and social standards, but they have a very high threshold, given that you have to look at injuries of substantial industry-wide repercussions. So WTO remedies will not help us anymore. And that makes us, or never ever helped, that we look at temporary remedies in the terms of compensation measures or the suspension of parts of the agreement. Tamara was mentioning it, that is the standard procedure. So if there's a certain treaty obligation that is violated, there must be first consultations, and after an arbitrational panel has stated that there is non-compliance, on the basis of this panel report ruling, temporary remedies can be adopted. This is adjusted when we look at labor and social, environmental, climate standards. Here we look at weakening or reducing those standards, provided that they are affecting trade or investment between the parties. As you know, as you have heard from my reading, I think there is a way that this can be interpreted a bit easier than what the Guatemala panel insinuated. If prior consultations failed, and here comes the only value that the expert panel report has. If the expert panel report says there's non-compliance, yes, they can come up with recommendations that are non-binding, but this report is the basis for trade remedies. So if now the European Union concludes, well, nothing is happening to this report, then they can start with their own remedies and have, in that sense, even a freedom to evaluate what is done if the UK is doing something else than what was even recommended by the experts. So in that sense, there's one legal importance to this expert report. Just to see how it is done with state aid, there's a different story. And state aid is in that sense a little bit stronger because consultations don't have to be failed, but only to be entered into. and they can therefore be unilaterally adopted trade measures. But now let's have a look at the rebalancing measure, at the rebalancing part. And here, my understanding is the following. Since ultimately, the remedies that can be adopted as a consequence of both procedures, the non-regression one and the rebalancing one, I believe the relationship between the two is the past and the future. So any weakening of the standards as they were on the 31st of December 2020, that is dealt under the light brown procedure, the non-regression one. But when there are divergences because of changes that happened thereafter, so if there is a change thereafter weakening what was before by UK legislation, it's the light brown one. But if then thereafter the EU is raising the bar, and that leads to significant divergences because the UK is not moving along, then the rebalancing measures can be started. So rebalancing is a tool by which the European Union can manage, to some extent, unilaterally regulatory alignment. And the tunnel between of alignment is the one of significant divergences. This is a big one. This is a broad one. No discussion about this, but future will only show what it means actually in detail, since they are going to be panel reports that are going to look at this. This is open for labor, social, environmental, and climate protection or subsidy control. We have some way of having it actually unilaterally because consultations are very short and they are deemed to be concluded after 14 days. And if there's nothing, then it's failure. And from that moment on, rebalancing measures can be adopted. Then the other party has the possibility to call on the arbitration panel to discuss whether rebalancing measures are consistent with the agreement. And here we have a little interesting backdoor detail in my eyes, because procedurally, under rebalancing, the one who thinks there is divergence can ultimately apply remedies. And the party against it has then to go to the court and now say, these remedies are actually not in line with rebalancing provisions. And if we look at the standard division of the burden of proof between parties, those that are claiming something, they have to prove their case. So we have here indirectly a reversal of the burden of proof in the rebalancing procedure compared to the non-regression one, because in front of the arbitration panel, it's then, for example, the UK, if they did, that has to prove that there is no significant divergence, in contrast to the EU that has to prove that there is one. But that might be a minor indirect detail of this. Now that brings me to the end of the presentation and some preliminary, because there are a couple of years to come, conclusions in the matter. The TCA goes beyond any protection of labor and social standards in other EU FTAs. This is going to be the minimum standard under which the EU cannot go below. And that's already good, because if you look at everything else what we have before in terms of labor, this is better, though not perfect. Because it repeats the limitations to non-regression clauses known from other free trade agreements, especially by the US, by referring to the limiting clause in a manner affecting trade. There is unclarity about the scope. We have the Guatemala case that in my eyes is, however, overruled, in a sense that it can be overruled. Once again, there is no stare decisis when we look at this kind of agreements. And the special EU-UK relations in terms of labor standards, I mentioned it earlier, compared to the US-Guatemala ones, given that they are actually on the same level when they are started their relations to each other, are a very strong argument that this limiting factor is to be interpreted in a very, very, very limited manner, by that opening more and more scope also for both non-regression and rebalancing. The actual innovation of this agreement with regard to international trade law is the rebalancing measures that look at future divergences due to the increase of labor and social standards within both, actually, the EU or the UK. Whilst the latter is not very likely, but legally speaking, it is a possibility. Thanks a lot for your attention, and I'm looking forward to our discussion.
Well, thanks, René. Thanks indeed. It was really an excellent overview, and you gave us an incredibly rich set of considerations. Particularly nice, this non-regression, which looks at the past, and divergences looking at the future. Now, let me now open the floor for questions to our four speakers. I would be inclined to give preference to one of the questions that have been already written in the chat. Of course, you, all the participants, please feel free to write your questions in the chat and or to ask for a live question, so to say. Now, there's a question. The first one is to Tonia and Tamara about health and safety provisions. What happens to the dynamic reading of existing directives to new situations? I don't know, Tamara or Tonia, if you had a chance to give a look to the question. It's in the general chat by Ode Cefaliello from the European Trade Union Institute. And feel free to pick up the question.
I'm happy to try to speak to this. This is obviously a really interesting question, and Tammy is more the expert in healthcare than I am, so she may have much more useful, perhaps, comments to make. But I think, as I would understand, the EU withdrawal agreement and the EU Withdrawal Act, we would still regard the litigation that was brought by the Independent Workers' Union of Great Britain as, and this was brought against our Secretary of State for Law and Pensions, as still governing the ways in which the Framework Directive 89/31/EC and the daughter directive relating to PPE operate in the UK. So just to give people an idea of what that litigation was about, this was a case which was decided on the 13th of November 2020, and it was a significant judicial review decision which expressed concern that workers were not adequately, especially atypical workers, were not adequately covered by UK health and safety legislation, our 1974 Act, in the context of the coronavirus crisis, that there should have been more stringent obligation on employers to protect health and safety and protect them from detriment where they refuse to work, where there is serious or imminent danger, and also that workers should have access to PPE rather than simply employees. And it was a significant finding on judicial review that we have to change the parameters of how our health and safety legislation applies. It was one of those examples which shows you how significant, I think, EU law has been to the development of labour standards in the UK. So extending the application of the Framework and PPE Directive in our domestic legislation. That judgment still stands. It is still good law, and I would hope that it is still possible to apply EU directives in that way to push the boundaries potentially of how we interpret existing legislative provisions, because those directives remain part of our law post-Brexit. But it is going to be more difficult to achieve. My sense is that much more will be left to UK courts to their discretion to interpret the meaning of these directives, whereas previously we might have thought about a reference to the Court of Justice. So cases like Locke, which were really significant for us on holiday pay, will not be possible in the same way. And the same would go with the health and safety regime. But at the same time, that case, the IWGB case, is still good law. And until we actually see legislative repeal of those provisions, and these are the Health and Safety at Work Act of 1974 is one of those provisions which should require parliamentary debate. at that point, we'll find out what this means in practice. Sorry, that was a very long-winded response. Tammy, do you want to come in on that?
Thank you, Tonya. That was a very useful response, I think, because people may well not be aware of this particular judicial review. I would only add to what Tonya said that the specific question that's been asked, and thank you for the question, is what are the ways to enforce or refer to EU directives in the UK at the end, after the end of the transition period? And the answer to that is that it's covered, as we've heard by the presentations, this is a matter for domestic law. And the relevant domestic law is the European Union Withdrawal Act. I've just found my copy of it to make sure that I'm remembering exactly what it says. And Section 6 of that Act explicitly says that when a domestic court in the UK is interpreting retained EU law, so here the directives, they are not bound by any principles or decisions made by the European Court of Justice after exit day. So there's no binding continuing effect according to the domestic. I mean, that might not be the case if we correctly interpret the Trade and Cooperation Agreement. I think that's a different question. But under the British Act, there's no intention to refer to post-2020 jurisprudence of the Court of Justice. And British courts cannot obviously make a preliminary reference either. But British courts may have regard to what is happening in the European Union. And what we don't know is to what extent British courts will have regard to what is happening in the European Union. And to some extent that will depend, because of the British legal system, it'll depend on exactly what kinds of arguments are made by the barristers in the relevant cases about the extent to which British courts will have regard to what is happening in the European Union. But there are no ways, I mean, the straightforward answer to the question as asked is that there are no ways to enforce the directives other than the ways that are provided in domestic law.
Thanks, Tommy, very much. Giacomo, you wanted to revamp the discussion on this, and then we have a question in the chat.
Yes, thank you. I just wanted to add exactly what Tamara was just saying. Let us not be too formalistic. Judicial dialogue and quotation of other cases decided by other courts all over the world, not only in our geographic proximity, is well established. So I would see no surprise in, also thanks to the argument put forward by the parties, I would not be surprised to see that there is an alignment to a certain extent. Let me just add, in more general terms, as an EU lawyer, I love the reference to Dassenville, but as an internal market professor, I have to remind that Dassenville is about goods. It's not about services. It's not about workers. It's not about standard. It's about making sure that EU law applies there where you need to build the internal market. For social rights, that's a different story. So let me remind you that the legal basis here, former 137, it was the need to ensure compliance with international obligations. It's the European Charter that was relevant here of 1961, as adapted in 1996, of course. But there was a need to ensure compliance with international standards, which are part of the legal framework that Professor Repazzi was so brilliantly illustrating. So, and in this regard, I would look at core fundamental rights, and there we look at ILO. Okay, then there are higher international standards, European Social Charter, and then there are even higher international standards, the EU law. Okay, and then you have a UK that is now a state part of the international community. So in regard to the relationship that we can in the future see between the UK and the EU in terms of social protection, I think we should not be too, again, formalistic and think that there has to be absolute, that the two legislations can be juxtaposed. I would reason more a little bit a la Bosporus, I would say, if you allow. So in terms of equivalence. So yeah, I would insist on flexibility, because what you want is to prevent, but I see no particular risk in this happening, prevent lowering so much the standards of protection of workers that it would be, from an axiological viewpoint, inadmissible for the EU to continue to do business. Okay, because that would not be compatible with fundamental rights. Let me just add, and then I'll shut up, that this non-regression clause has been, in a very different area, invoked very recently by the Court of Justice, in the field, of course, of the rule of law. And here it basically stated that once you enter into the union according to the parameters dictated by Article 49 TEU, then you don't go back. And this is, of course, a clear message sent to Poland and then Hungary. It's a clear message. I don't know how effective that will be, but okay, I'll stop here. Thank you very much.
Thanks, Giacomo. Now we have 3 questions at stake. One by Pierre about the European Social Charter, another one by Valentina, who would like to have the floor, and another one internally in the panel from Tamara to René. I would start from Piera, since we wouldn't go too long. I think we have around 20 minutes of discussion. I would say, first of all, who wants to pick up the question on the European Social Charter? Tonia, please. Thanks.
I really like the idea of using the European Social Charter as a bridge. There are some technical domestic legal difficulties in the UK, which is that the European Convention on Human Rights has privileged legal status because of the incorporation of convention rights into our domestic law through a Human Rights Act of 1998. And what we're finding is that because European Court of Human Rights judgments tend to refer extensively to ILO standards, that those are beginning to seep through into our domestic jurisdiction. Of course, the European Court of Human Rights does also refer periodically to European Social Charter, and particularly the findings of the European Committee of Social Rights, in ways that could be really helpful in providing that bridge, but it doesn't tend to do so as frequently. And you do get the odd case like RMT in UK, where the court simply refuses to apply ILO and social charter standards and understandings of those. So I would watch that space, and perhaps you're right to see the glass half full, but it is going to be difficult to give the European Social Charter that status under UK law.
Thanks. Thanks very much. Valentina, please go ahead.
Yes.
Thanks.
Thank you, Luca. Yes, first of all, I would like to thank you all the speakers, because this has been a very high-level webinar, and I think one of the first on this topic. So I thank you very much for your useful analysis. Well, I have a quick question for Professor Repasi. About the famous expression "in a manner affecting trade" written in Article 387. Well, I was wondering if, in concrete, if the European Union, for example, is lowering some labor law provisions in terms of working time, for example. Well, in practice, if the UK want to complain about these new European Union provisions, who will be entitled in practice to check it? And I have a lot of other questions. For example, which tools must be used to measure this affection to trade, and how should be this effect? Could it be the case of a very limited effect, or this effect should be of a certain measure, of a certain level to block the European Union action? Well, as Professor Repasi already reminded us, the standard of proof is very high, and I perfectly agree with him. And as a matter of fact, in the Guatemala case, the US were not able to demonstrate that affection of trade. So I think that all the lack of information could be considered as a limit to the real power of this clause of non-regression. And well, I would like to know your opinion about that. Thank you very much.
Renee, I think you have a hard time now. You have two tough questions. Go ahead.
Should I also already address the one by Tamara from the chat?
Yeah, why not? Thanks.
Good. Now then, first with the question from Valentina. So this is of course a case that in Brussels it's not discussed. It's always discussed that the UK is lowering and what can the EU do. But you rightly point out the fact that this is a two-sided rule. So if the EU lowers, then the UK can also do something about it. Then the UK complains. It has to enter into prior consultations. The consultations can have some kind of consequences or not. And if there are no consequences and it is failed, then the expert of panel has to start is judged. This panel of experts, is composed of members that are defined by this agreement committee on level playing field. And they issue then a final report, an interim report, which you can state, and then there's a final report. If this final report says that there is no weakening of, or no lowering, so non-issue of non-regression, then there is a necessary condition not fulfilled in order to adopt trade remedies. So from that moment on, trade remedies and the non-regression cannot be adopted anymore. And what these panels decide is not open to appeal, so you cannot go to the arbitration panel or anything like this. That's then the end of the game. So under the non-regression clause, if this panel decides negatively, or it says what the EU did in your case is in compliance with the rules of the agreement, then the UK cannot do anything else within the non-regression procedures. One may then turn to the wording of the rebalancing clause is open. My understanding is that it looks at future divergence, but if then it makes this distinction. But the difference between rebalancing and non-regression is that rebalancing allows unilateral measures. So also there has to be consultation, which must fail. But once they are failed, then the UK could adopt trade remedies against this, and the EU could then go now to the arbitration panel, not to the panel of experts, but the arbitration panel, and request whether the rebalancing measures are in line with the trade agreement. And this is the case if there are not significant divergences between the EU legal framework and the UK one, which then has to be proven by the European Union. If the arbitration panel says, indeed, there are no significant divergences, then the UK has to stop its trade remedy measures. If they don't, then the EU is entitled to countermeasures. And that already shows that we are going back into the 19th century with the trade agreement. So we are fighting against each other with trade remedies and counter remedies, something that the EU has overcome with the judicial procedures that we have at the European Court of Justice, so that we don't have to go to this medieval fighting between each other. I'm afraid we are going to have a couple of years of this until the ultimate revision clause of after 5 years, the whole agreement has to be revised, comes into play, and we learn from what we have done in the last 5 years. But I'm unfortunately in that sense not very optimistic. So when we look at the second point, lack of information as a limit, that ultimately depends on the understanding that
No.
Sorry?
Go ahead.
that ultimately depends on the understanding that a panel of experts, or in the rebalancing procedure, the arbitrational panel, gives to these limiting conditions of manner affecting the trade between the parties. If they are going in two directions as the Korea panel, then the lack of information will not become such a big problem, because then the understanding is any weakening of labor standards is inherent to trade, and therefore any weakening is actually affecting trade. If it goes more into the direction of Guatemala, then you're entirely right. Then information is the problem, and therefore the solution for this is who has the burden of proof. And that's precisely the reason why the US and the USMCA decided to change the burden of proof, so that now Guatemala has to have enough information in order to prove it, because we will come in this kind of situations, as you rightly point out, into a non-liquid situation where burden of proof division is going to be decisive. So in that sense, if we uphold the standard of Guatemala, then indeed lack of information is a limit, which also in terms of EU means if the EU is smart, then they are adopting secondary legislation that allows trade unions on the EU side, which have good connections then to what is happening on the ground in both sides, EU and the UK, to trigger those procedures via the European Commission, because they can give all the information that the European Commission might need. So close cooperation with those civil society actors on the EU side is going to be crucial. And in that sense, Tamara, I have in part, now to your question, the question, EU-Korea panel is basically part of the external relations acquis. Indeed, it is part of the EU external relations acquis to the extent that the Korea agreement is affected. Already outside of it, it is not part of the acquis anymore. So it would not apply to CETA. It would also not apply to any other trade agreements. Since then, a new panel has to make a decision in light of this agreement. Yet, the argument is very compelling, especially from an EU's perspective. So also legally speaking, that makes me that I think a panel of experts might come to similar conclusions. And provided that they do, then it becomes also part of this acquis. Yet a panel is, of course, an agreement institution and not an EU institution. And in that sense, it is, let's call it guidance for both parties, but then, of course, in accordance with the standards of the respective legal regime. So on the UK side, it then very much depends on what they think of it. Ultimately, we know if we are having a low standard, that will open the doors to trade remedies from the EU, and then the UK government will have to decide, do we adopt countermeasures because we think this is not right? And will then there be any discussion on those countermeasures? So then we are going back into this medieval kind of fighting. And there it comes then, does the UK consider it binding upon itself or not? Legally speaking, it is not as binding as probably on the EU.
Thanks indeed, René.
Thank you.
A debate was then in parallel developed in the chat. One of the questions there is, and I think it's for the four of you, generally speaking, is the reading that René proposed, so the progressive reading to link workers' rights as inherently related to trade, is that sufficient to have an optimistic reading of the absence of a labor chapter in this TCA? This is Adalberto Perulli particularly who focused on that. Any reaction from your side? René, please.
Yeah, I can do it quickly because the clear answer is no. What we have with this is that we activate those clauses that manage a sort of dialogue between the EU and the UK on labor rights in a negative way, because it's ultimately done by measures and countermeasures, that we allow this kind of dialogue to happen. But this is far away from any proper labor chapter with ideally even harmonized rules. But if we have harmonized rules, of course, we have legitimacy questions. Is there a parliamentary chamber with proper parliamentary input, etc., then we would need to have a mini EU in order to have proper harmonized labor standards at agreement level. But the answer is clearly, this is no replacement whatsoever. It's just quite of a minus, but opening the doors to get something started that looks like a regulatory alignment.
There was a paragraph in Bob Happer's book about winners and losers. So this is very much probably what we are discussing here. Tonya, thanks.
Yeah, I just thought maybe it might be worth adding in the concerns that have been raised in the past relating to the attachment of labour clauses to sustainable development chapters and also to conditionality around trade. There is a concern raised by commentators such as Laurent Bartel and Jan Orby that we ought to be thinking about labour standards more as fundamental human rights clauses, and that we ought to be thinking about these more in ethical terms than in terms of whether or not compliance affects trade. And I think that's why the Guatemala case got such reaction, because there were such blatant abuses and assassinations, which somehow were not seen as worthy of a trade response. So I do think that this sets a dangerous precedent that we're going to have to keep a watch on and see how this pans out in the longer term. I also do think it's unfortunate that there is this express provision about a lack of legal effect for the committee of, the panel of experts, just because we know from the EU-Korea findings that even a legally binding decision by a panel of experts has relatively little effect. And this impacts upon the ways in which the findings of a panel could be applied in a domestic legal setting. I think Tammy said accurately in the chat that we might want to be able to use the European Social Charter as persuasive in terms of how we actually apply UK domestic labour standards, and that would be in line with our obligations under international agreements and under the TCA. But the express provision that the finding of a panel of experts is not legally binding seems to block that to some extent, which is unfortunate, I would have thought.
Tammy, you wanted to reply to that?
I just wanted to say something about this discussion about harmonization and alignment. So I would say, I mean, certainly in the area that I study, which is health, so everything from health products to health people to health services, the relations between the UK and the EU in terms of high politics are at their absolute worst at the moment. They are absolutely awful. But I don't believe that they will stay like that. And I don't believe that this narrative of control and divergence which is happening at a high politics level, will actually permeate to a low politics level. And the reason that I don't think so is because it doesn't work for anybody. It's just not practical for anybody. So just to give an example, the other day I was talking to somebody who explained how the European Blood Association managed to keep the UK as a member of the European Blood Association. And they did it by looking very closely at the European Blood Association's constitution and saying, there's no provision in this constitution for a country to leave. There's a provision that says you can be a member of the European Blood Association if you're a European country and you're compliant with the EEA rules, but it doesn't say anything about leaving. So the UK was compliant when it joined, and we're just going to leave it alone. So at that very practical level, there is a desire at the level of low politics to continue to align. And I think that will matter going forward. I believe we will look back on this time as the very worst relationship between the UK and the EU. and that things will actually get better. And one of the good things about the Trade and Cooperation Agreement is that it does give some procedures and places and spaces to continue alignment or have new alignment. And the topic that Giacomo talked about, mutual recognition of professional qualifications, is one of those. So I think that one thing that it might be interesting for us as labour and social lawyers to look at is, are there low politics things in areas like transport, for instance, where there's an agreement to align, irrespective of what the UK government might be doing or what narrative it might need for its voters? And I think that is where we should, when we are looking about glass half full, and I would like to do this and be optimistic and stay friendly with my European colleagues and friends and neighbours, I think that's where we should look. We should look above the big politics narrative. Sorry, I meant to say one short thing and I said one very long thing.
Thanks very much, Tammy. Well,
sorry, Luca, can I say something?
Sure, Giacomo, go ahead. Thanks.
Okay, thank you, Tamara, for mentioning mutual recognition of professionals as one of those areas in which I think that this low moment of relationship it can start from there. Okay, cooperation can start from there. I absolutely agree that on the low level, like sharing of data concerning COVID treatment, for instance, that's another area where a low cooperation will still be possible, I think, because it's mainly left to individuals and those who operate closely with patients. I wanted to say that in my presentation, one of the objectives was precisely to suggest that people don't move for working standards. People didn't move to the UK to say, oh, I want a better working standard, so I think I'll move to the UK because it's unacceptable for me here. And I don't think it worked the other way around either. So I don't think, or I didn't see this as a perceived reason to move. Now, so having this in mind, I think linking labor rights with fundamental rights, with the rights of the individual, this is great, this is fantastic. We've been arguing this in the academy for a number of years, and that is fine. But this is not a driving force in the real world out there, okay? So we might say, okay, there are fundamental rights. That doesn't take away violations of those fundamental rights. I think what the panel would be looking more at is the economic impact. And so if I have to look at healthcare, I have to, I remember that with the Lisbon strategy of 2000, healthcare was recognized as a factor of growth. And if we look at what happened to the regulation to regime applicable to healthcare, 280 degrees, we've seen more EU in healthcare because there was the economic component behind that justified in a very peculiar system, such as the one of the EU with the principle of conferral, that justified forcing a little bit the system or exploiting the system more. Okay, I'll leave it to that. Thank you.
Thanks very much, Giacomo. Thanks to all the speakers. It appeared a very last question, but it's very, very late now. It's on Social Security. So may I kindly ask Maite Sester to address directly the question, maybe in private, to the speakers. Because I think we need to conclude our very interesting seminar. Thanks very much to you for having made this possible. Let me remind that this labor law community is quite active. It's promoting more and more events and conferences and webinars. The next one will be the 10th of June on the impact on the AI regulation proposal on workers' rights, where also we will feature again Tonia as general discussant of the conference. A very warm ciao to Manfred Weiss. Thanks very much for being there. A point of reference for all the labor law community. Thanks very much. Now, once again, thanks for having participated. It was very, very nice, and see you next time.